Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3042, United States of America versus Couy Griffin appellant. Ms. Wright for the appellant, Mr. Leonard for the appellee.
Good morning, Ms. Wright. You may proceed when you're ready.
Thank you. May it please the court, on behalf, Lisa Wright, on behalf of Mr. Couy Griffin, I'd like to reserve 2 minutes for rebuttal. Mr. Griffin was convicted of one misdemeanor count of knowingly entering or remaining in any, quote, restricted building or grounds. A restricted building or grounds being defined as a posted, cordoned off, or otherwise restricted area, and 2, where a Secret Service protectee is visiting. And I believe it may be helpful for me to use the shorthand RBG as a way to distinguish restricted building or grounds, which is a congressionally defined term of art, from the words restricted area, which are also in the statute. The government's proof was insufficient to prove this entering and remaining charge beyond a reasonable doubt, and it was insufficient for 3 independent reasons. 1, the government failed to prove that any area Mr. Griffin entered had the status of an RBG at the time he entered, where the government did not prove that such area was at that time posted, cordoned off, or otherwise restricted. 2nd, even if this court were to accept the government's theory that an area can be, quote, otherwise restricted, even without any on-site public notice, the government concedes that Mr. Griffin had to know the area was an RBG, and the government failed to prove that Mr. Griffin knew the area was otherwise restricted at the time he entered. And 3rd, and I think number 3 is the easiest way to decide this case, even if there were sufficient evidence that Mr. Griffin knew that an area he entered was otherwise restricted, the government failed to prove that he knew the other fact necessary to qualify the area as an RBG, that it was an area where a Secret Service protectee was or would be temporarily visiting. And any one of these insufficiencies requires the entry of a judgment of acquittal for Mr. Griffin. I could just go through them.
Why shouldn't we treat the definitional provision as a provision that's in support of federal jurisdiction? I mean, trespass is typically a state law offense. And under FEOLA, which to my mind may be the closest case, and I know it wasn't cited in the briefing here, but under FEOLA, the question was whether the knowledge requirement applied to assault victim status as a federal law enforcement agent. The person was undercover. And the court held in that case that the knowledge requirement, well, that there was no scienter requirement extending to the federal officer status of the victim. And I wonder why we shouldn't think of this statute in the same way.
I am fairly certain that the word knowingly is not in 111, which is FEOLA.
I think you're right.
Yeah. So I think that's the answer to that. And here, Congress was only interested in doing this at all. This is not a jurisdictional hook. Like, this is something they want to do. They want to keep people out of areas that they mark off. It's only because of the 3 reasons that the White House, the protectee, et cetera, that they care at all to do it. I mean, it's the reason that it's not a hook. It's not something they want to criminalize anyway and have to find a way to bring it in federal jurisdiction.
No, but as I said, ordinarily trespass, entering restricted areas is typically dealt with under state law. And if this provision were unavailable, then there's not another way that Mr. Griffin could be charged for entering a restricted area under federal law. And I don't know, would trespass law, DC trespass law, apply to crossing a keep out sign? I mean, assuming, I know you have a challenge to whether in fact the grounds were restricted within the meaning of the statute, but assuming that they were, there's not an offense other than the one charged.
I'm not aware of a federal offense. I think 3056, if he were to interfere with an officer, a Secret Service agent or something like that could be charged. I believe that before 1752 for example, the White House was explicitly put in, it's my understanding that they used to prosecute that under the DC code. Don't know if that could have been, I don't know how
As a trespass?
I think as a DC, some sort of DC
Right,
trespass.
going into White House grounds.
Yes,
Unauthorized.
that's my understanding, and that part of the purpose of putting the White House in this federal statute was so they wouldn't have to do that. But I don't know if that would be true in the Capitol, on the Capitol grounds.
One thing we look to in positing mens rea requirements is whether the element is necessary to separate wrongful from innocent conduct, right? And this seems like a little bit of an intermediate case to the extent going into a posted, cordoned off or otherwise restricted area is wrongful conduct. You don't need anything else to establish wrongful conduct, but the presence of a Secret Service person protected by the Secret Service seems to make the wrongful conduct a fair amount worse. So how do we think of that kind of situation?
Right, well, that would be assuming that he had to know that, which,
Yeah, I'm asking, I mean,
Right,
the question is whether we should extend
right.
the knowingly adverb all the way down to that
Well,
last element.
again, we would say it isn't being extended. I think that.
Applied.
Yeah, applied. But the point here, I think the bigger point is that I don't think that analysis that Your Honor is talking about actually applies when the plain text is, the modification is as directed as it is here. This isn't a case where a presumption is being applied.
No, I understand. You have a grammar argument that, right, the adverb applies to the direct object, which is grounds. Grounds is modified by a bunch of singular adjectives that precede it and later adjectival phrases that follow it, and you can't distinguish between those two. It's a matter of grammar.
Right, and it's a term of art that's defined that you simply plop in. You're not extending knowingly to elsewhere in the statute. And I think the Elizalde opinion that we submitted with our 28J letter,
That was the one Judge Nichols just decided.
Correct, on Friday. That I think explains all of that we're not, buttresses our argument that we're not extending it at all, and also addresses the point Your Honor is making about otherwise innocent conduct and how that really isn't a factor. That's not something the court even needs to consider, here. But I mean, if that were true.
But I'm sorry, doesn't that cut against you that entering a posted, cordoned off, or otherwise restricted area is wrongful conduct? So that would distinguish this case from the McFadden case, from there's a series of cases with the Rahif and Staples, where without the knowledge of the gun being a machine gun or the person being an alien, or I'm trying to remember the other one, the person being, anyway, that those are, the line there without the knowledge is that you're engaging in innocent conduct, and the knowledge is the thing that ensures that a person is being punished only for culpable conduct.
Well, I would say first, Flores-Figueroa is an example of where the court applied the knowledge. It said unauthorized use of a identification, and that is already wrongly using an identification. But the phrase tacked on at the end, belonging to the person of another, they nevertheless extended that to that, even though it was already wrongful to be using another person. I mean, to be using, I think it's fraudulent identification. It was in some way they defined identification in a way that was already wrongful, but they wanted to specify that it had to have someone else's name on it. And that part was added on. But again, I think that the court uses that rule when it's left with, contextual clues, or it's something it's trying to look at, it's moving on to congressional intent. And I don't think you do that here where the plain text, it just says it. The government admits that knowingly modifies the term restricted building or grounds.
Right,
Let's
and
see.
you've, I think, very effectively argued in your brief that restricted building or grounds is a term of art. But if we don't agree with you, then you lose, right?
No,
You have to sort of, that's how you get to the separate definitional section and carry the knowledge over to it.
well, I would say Rahafe is good for us. Also Flores-Figueroa. I think we win under Flores-Figueroa even without the idea that it's a definition. But it clearly is a definition. So we don't even get there. But if we did, we would still be relying on cases like Rahafe and Flores-Figueroa primarily, I think, as the reason why we should think that Congress meant this to be included in the knowing.
But here, as in Fayola, the definition identifies 3 different circumstances in which there's a distinctive federal interest. So it limits the entry into restricted building or grounds to those that are going to be subject to prosecution federally for that subset.
Well, they're defining a crime that they want to punish. And the crime is getting in a restricted area where a protectee is. And that is the crime. Like I said, it's not just like, oh, we want to prosecute you for going in an area. And so this is like a jurisdictional hook. And again, Fiola, I understand, and if the word knowingly is not in Fiola, I just don't see what we can draw from that at all, because there they were just having to look at like, what do we think Congress intended? And here we know what Congress intended. The government's admitted that it modifies this term. And I do think the McFadden case is directly analogous, because there the term controlled substance was defined not only in a separate section, you had to go 2 sections away to find it, and then you had to go through a list of schedules that was like, 3 pages long. And they said, yes, you can, you have to prove that he knows that that substance he has is one of the substances. He has to know it is a substance. And that's.
One way of understanding that is, as the court says, either he has to know that it is, in fact, a substance that is controlled, even if he doesn't know about the control system, or he has to know that it's
Correct.
under the control system. And that would, either of those effectively distinguishes it from, let's say he thinks it's heroin, but it's actually, ginseng powder or something. And, so I want to go back though to your restricted, what makes a grounds, building or grounds restricted. And you talk about how it has to be demarcated in a way that's similar. It has to be posted,
Cordoned off. Or otherwise restricted. And otherwise tells us that it has to be in a way comparable to the words that precede it. So giving comparable notice and publicly demarcating it in that way. And we would rely on, the government says Fisher's definition of otherwise controls, but Fisher explains why it's actually Begay, not Fisher, that is relevant here. And so I don't think can be much dispute that the word otherwise is linking back to those 2.
And what does that get you?
Well, those 2, a posting and cordoning off is obviously the purpose of those is to notify the public there at the border. It is saying like you line up police, that's a cordoning off. You post notices. So
it's a temporal point that, because the most typical, as I understand it, the most typical way that people are informed that a Secret Service protectee is present is just Secret Service agents telling them.
That is
so it's in some very obvious way not analogous to posted or cordoned off, which is typically done with signs or fencing. A moving group of people telling you is very dissimilar in some way, but you're using it to say that it has to temporally be at the moment of entry.
And at the moment, at the place and the time. And I do think a Secret Service agent telling you what would otherwise be on a sign.
It's materially analogous.
It's the same.
Yeah.
The point is you have to tell them And you could tell them via a bullhorn, giving an overhead announcement. I think that's a lot of, we know how these, civil disobedience things happen. At least they get the bullhorn and they say, do not cross the street. If you cross the street, you will be arrested.
And how do you respond to the hypotheticals or the reality of people who get there first, removing the barriers, and people who follow on, who are well aware that they're entering an area that's restricted but don't see the barriers because they've been shoved aside? Is that not prohibited by the statute? I take it that's your argument. That's not prohibited by the statute because it doesn't give the sufficiently contemporaneous notice.
Well, our position, of course, is that Mr. Griffin was so far behind that he is not in the category you're talking about of knowing well. I understand what you're saying is there were some people who, although they personally didn't knock them down, saw them being knocked down and followed along. And I would say, if those people are seeing that it is a line and they are pushing the line back, even if they're 10 rows back, but they are part of the push, they are attempting to enter a restricted building or ground. Shall I?
Possible that we would get less if you turn volume down slightly.
Sorry. I was told to be close, so I may be talking too loud.
We are upgrading the audio system, and so we're still in early days of fine tuning it, but we can hear you quite clearly.
Oh, okay, good. So the people that actually break through the line, they actually enter and remain. But the people that are pushing behind them and see what's happening, those people are attempting to enter and remain. They're just not the ones that break through, but they're pushing the line back. But the people like Mr. Griffin, who was at the Air and Space Museum at the time, passing the Air and Space Museum, wasn't in the museum, at the time that the fencing is being ripped down, he doesn't know it all. So, that's how I would distinguish it. Seeing it versus not seeing it, being aware. And I want to, step back a second on this statute. And, it's not an ordinary trespass statute. It doesn't criminalize the crossing of existing public or, private or, any sort of property line or boundary that pre-exists. It gives law enforcement this extraordinary power to carve out like pop-up zones of protection that are moving. And because of that, they can create this zone within any public or private property, even including, as here, a First Amendment public forum as sacred as the U.S. Capitol grounds.
I have a question about standard of review. You raise a argument that the evidence was insufficient. Aren't there sort of two components to your argument? And one is interpreting 1752, and the other is sufficiency of the evidence. And do we review the district court's interpretation of the statute for plain error?
No, because I believe our interpretations were put forward and rejected. The court explicitly ruled we have raised two legal mistakes. One was the one about whether you have to know the protectees present. That was raised and ruled on and rejected. The other argument, we raised the canons of statutory construction and argued that otherwise restricted meant, comparable notice. And although the judge did not explicitly reject that, he found that Mr. Griffin had entered the restricted area when he crossed the Olmsted Wall, even while finding that that area was not at that time posted. So he was applying an incorrect legal standard.
But he also found that that Mr. Griffin was aware that the area was restricted. And I know you contest that.
Yes.
But he did find that.
But he found that not at the Olmsted Wall. He found that by the time he was at the stage. So he really does find that he's entering the area at the wall, even though it's not marked, but he doesn't know he's entered it until later. So I guess the standard review question is, we see these two legal errors as akin to erroneous jury instructions, which were preserved. But the court doesn't even, the remedy here, because the evidence is insufficient under the correct standard, the court should, remand for entry of judgment of acquittal on any one of the three arguments we raise.
Why is Under your interpretation of knowingly, why is the evidence legally insufficient? I mean, everyone there knew the vice president was in the Capitol. That was the whole point of the certification proceeding and the protest.
On the knowledge element of the protectee's presence, you're asking factually.
I'm sorry.
I'm saying that you're asking factually
Right.
on the protectee's
It
presence.
seems to me that's a litigable issue under your interpretation.
Well, I would say Mr. Griffin is very uniquely situated on that particular factual issue because we know that at 1:45 p.m., 45 minutes before he ever entered, he was under the mistaken impression that the certification was over. And also before he entered, I'll just say that.
When did he enter?
2:31. And we know that at least as of 1:45. I mean, he's saying it at 1:45, but I mean, I guess what the
Do you
point is.
think a trier of fact could conclude he thought the vice president was probably still in the Capitol
Well,
5 minutes later?
I would say there's zero evidence really that he knows that he's in the Capitol, and the Capitol is under attack. Okay, so the logical inference is I would say it's conceivable. One could conceive that he might think that Vice President Pence would finish his duties there and hang out for 45 minutes, even though
Maybe. Maybe he really thinks it was certified and vice president gets the heck out as soon as he can and he's not there. Maybe 45 minutes isn't that long. Maybe he thinks he's
under the
hunkered down.
cafeteria. Yeah. No,
Office, just has an office at the Capitol, and if this is certified, this is the end of his duties. And
true, and perhaps I would just say that you could conceive that he could think that, especially in normal circumstances, but having it be a possibility doesn't mean that a jury could find it beyond a reasonable doubt when there's all these counter inferences. And I would say even in normal circumstances, the vice president's movements are quickly controlled. I agree, he has an office there, but these were not normal circumstances. Anyone would expect that with the Capitol being surrounded, that the Secret Service is going to whisk him out of there. By the time he's crossing the wall to a top secret, by the time he crossed the wall, he had in fact been whisked out to a top secret location that no one knew where it was. So the idea that Mr. Griffin knew beyond a reasonable doubt that he was, even only the detail at this point knows whether he's even on or off the grounds. And in fact, it wasn't until this case that the Secret Service was forced to reveal where he was. So the idea that Mr. Griffin knew he was on the Capitol grounds when no one knew where he was, that's the point. He was under attack. The crowd had been inflamed by a tweet about 7 minutes before he crossed over that said Mike Pence didn't do what needed to be done, didn't have the courage. So the Secret Service is not going to let him stick around. And I would just say.
But I mean, the members of the crowd were chanting, saying things as if they were speaking to like Pence in the building. And so there is evidence.
A couple points to that. I mean, they aren't under the misimpression necessarily that he is. Protesters yell at the White House. They yell at the Capitol. They yell at people. Everyone understands they aren't really talking to the person. But also to the extent they are yelling these threatening things, directing to Mike Pence, all the more reason that no one would think the Secret Service would allow him to stand. And I would say that Inspector Hawa, there is testimony on this that she said that the Secret Service has to move protectees when a security perimeter is breached, and they have to act before exit options are cut off. So that's evidence that raises an inference that they're getting him out of there. And that she also said, and there was no evidence that the loading dock was actually where they wanted him. She admitted that she referred to the loading dock as a quote secure location only because it was more secure than where he was before in the office. And we now know that he did end up staying within the yellow line, but only because he refused to get in the car. The Secret Service tried to get him off the grounds, as any reasonable person would think they would. And he had his reasons for staying, which were reasons that Mr. Griffin did not know because he thought it was over.
I just have one clarifying question about standard of review. You say the arguments were preserved, but wasn't the motion judgment of acquittal in the district court on the grounds that Vice President Pence was not there temporarily because he actually has an office in
He
the
did,
capital.
did make that argument.
And that's different from the arguments that you're making on appeal. So why doesn't plain error apply?
I did look at that. I'm fairly confident that the words that the trial counsel said were a general motion, at least at one point. And I think Judge McFadden assured him he was trying to make some arguments and saying, we need to resolve these now. And Judge McFadden said, no, don't worry, I'm going to wrap this into my bench ruling and everything is preserved. I thought he said something to that effect, because it was a little confusing, like what's the difference between the verdict and the MJOA ruling? And I thought Judge McFadden made clear, like, you've preserved everything, don't worry about it. And he certainly had preserved these legal arguments. So
we've taken you way over time, but we will some rebuttal unless counsel.
Well, just one more on
My colleague had a
on
question.
knowingly, and you said this was not a typical trespass statute. What do we do with the penalty provision? It's 1 year, it's a misdemeanor. That feels more like a federal version of trespass than like a statute that's directed at putting the president's life in danger.
And that points towards not requiring knowingly?
Correct.
Well, again,
Treating the presence of the protected person as more like a jurisdictional element than like the gravamen of the offense.
Yeah, I think, again, that you can't find language plainer, and we shouldn't be, coming up and trying to make inferences or presumptions about what Congress is thinking when we know what they're thinking because they said it. So that's my position on that. So we would ask the court to vacate and remand for entry of a judgment of acquittal. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court, Dan Lenners for the United States. The evidence in this case was sufficient for the district court to convict Couy Griffin of violating section 1752A1. In terms of the statute's knowledge requirement, the Supreme Court has repeatedly made clear that whether a criminal statute requires the government to prove that a defendant acted knowingly is a question of congressional intent. And requiring the government to prove that the defendant knew the particular Secret Service protectee who is located within the restricted area runs afoul of any inference of congressional intent for a statute designed to protect the president from assassination and to protect other Secret Service protectees, where knowledge of presence would tend to make those people less safe rather than more safe. And for that reason, the best understanding of how the statute operates is that a defendant has to know that he is in a posted, cordoned off, or otherwise restricted area, know that he is without lawful authority to be there, and nothing more. Those two.
And there has to be proof that one of the three conditions in the definitional provision was in fact present.
Yes, Your Honor, in terms of the actus reus, but not in terms of the mens rea.
I mean, text is your biggest obstacle here. We have Rahafe, we have Staples, we have McFadden, we have, effectively case after case with explicit knowledge requirements and the Supreme Court applying it all the way down.
That's true, Your Honor, but there are also cases like this court's recent decision in Morgan, where the court has not applied knowingly to a statute's element, where it's in a special context that suggests that Congress didn't intend that result. And ultimately, all of these knowledge cases, in terms of how far down into the statute you read that requirement, turn on congressional intent. And here, although in other cases, the Supreme Court has read knowledge to apply throughout, here there are strong indicia that Congress could not have intended that result to make, the Supreme Court has talked about the valid, even overwhelming interest in protecting the safety of its chief executive.
Before you get to that, do you have a textual argument? Let's just walk through it. The operative text is the adverb knowingly. Then there's the verb enter. And then there's the direct object of the verb, which is the restricted building or grounds. And you agree that the adverb extends to the direct object, right?
Yes, Your Honor, we do.
Okay, so then the question is, what does restricted building or grounds mean? And that's a defined term, right?
I agree, Your Honor, but I think here the difference between, say, this case and McFadden is the statutory history.
Let's just, let's just go through text and then I'll let you broaden the focus. Right, so we have this direct object, which is the defined term. You look in the definition and the key noun is area, right? And it's preceded by adjectives, posted, cordoned off, otherwise restricted. You agree the knowingly element applies to all of those adjectives, right? The person has to know that the area is posted, cordoned off, or otherwise restricted.
We do agree with that because of the statutory history.
Okay, and then after the word area is the dash, which says there's something significant to follow. And then there are these three possibilities, which are basically long adjectival prepositional phrases modifying the word area.
Which have further sub-definitions that the defense doesn't seem to argue knowledge further applies to, which suggests that there's some cutoff within the statute. Within...
What are you referring to, the further sub-definitions?
Within subsection C1B, it says where the president or other person protected by the Secret Service, and then C2 defines the term other person protected by the Secret Service, meaning any person who the Secret Service is authorized to protect when such person has not declined such protection. And the defense has never argued that knowledge extends to a defendant's understanding that the particular protectee has not declined such protection, for example. So even they seem to recognize implicit cutoff to the knowledge requirement in the statute.
So I'm sorry, I just lost you. Where are you in the statute?
So C1B says of a building or grounds where the president or other person protected, and then C2 defines the term other person protected by the Secret Service to mean any person who the Secret Service is authorized to protect when such person has not declined such protection. And the defense doesn't argue that knowingly goes all the way down to hasn't declined such protection.
Well, and C2 even has further cross-reference to section 3056, which defines who the United States Secret Service is authorized to protect.
That's true, Your Honor, or by presidential memorandum. And so the defense seems to recognize that there's some cutoff within the knowingly requirement to where it does not travel. And the statutory history is that these terms used to be within the criminal provision itself. So A1 used to contain of a building or grounds where the president or other person protected by the Secret Service is or will be temporarily visiting. And then it separately said that it criminalized entering a building or grounds so restricted in conjunction with an event designated as a special event of national significance. And so the fact that Congress moved those provisions out of the crime itself to a separate definitional provision, at the same time it eliminated the statute's willfully requirement, further underscores its intent not to require a defendant to know the underlying fact that makes the area restricted.
I'm so sure. I mean, the fact that it used to be in the primary text also supports an argument that this is just organizational and that, without affirmative indication that the knowledge was somehow deemed as inappropriate or the mens rea deemed as inappropriate to apply. I'm not sure that gets you much.
At the very least, it moves this requirement away from the knowledge requirement. At the same time, Congress eliminated the willful requirement. So
what's the constitutional basis for this statute, the congressional power?
I had that question leading up to this, and I'm not sure of the answer, but I think it's the necessary and proper clause to protect the chief executive and other people deserving of protection. It doesn't seem like the Commerce Clause is the jurisdictional basis. The defense has not challenged.
I think the legislative history refers to the General Welfare Clause.
That may be right as well, Your Honor. I'm not great with constitutional jurisdiction. The defense hasn't challenged it here. I'm not aware of any defendant who's challenged the jurisdictional basis for Congress enacting this statute.
No, it's more a question, I think, that could be helpful, or the answer could be helpful to you to the extent that, as in Fayola, the type of crime is one that's typically dealt with at the state or local level. And here there's a federal interest in a particular protection of particular areas based on, the three interests that are listed.
Yes, I agree, Your Honor. We made that argument in our brief that these designated areas are akin to jurisdictional elements and that they do not they don't criminalize otherwise innocent conduct. That by requiring that a defendant know that he go into an area that is off limits, posted, cordoned off, or otherwise restricted, and know that he is without lawful authority, that's all that's necessary to criminalize otherwise innocent conduct. And the fact that the defendant knows the president is there, knows it's the White House, knows it's a restricted in conjunction with an event designated as a special event of national significance is irrelevant to the criminal mens rea. But
about that C1C, that in conjunction with an event designated as a special event of national significance, why wasn't that the argument? Is there some process for designating a special event of national significance that wasn't undertaken here, or?
I believe that's right, Your Honor. The Secret Service, there are references to the Secret Service having the ability to so designate something. I'm not aware of that designation occurring here. And in fact, I'm not aware of when that designation is ever employed. But the legislative history suggests that because the Secret Service is responsible for protecting the president and other protectees, it is also has some responsibility for protection at these events. And that's why this initially separate provision was included within the statute.
What if the Secret Service and the Capitol Police had internally declared the U.S. Capitol grounds to be restricted? And you're not arguing that there's no need to have something like posted, cordoned off, or otherwise restricted?
No, Your Honor. I don't actually think there's that much daylight between the defense and us as to what otherwise restricted means. The government recognizes that, otherwise means either in a different or in a similar way, and then restricted means, made less accessible, and so there has to be something that makes the area less accessible to other people. It doesn't have to be physically inaccessible. Posting doesn't make an area physically inaccessible. It's unclear that on-site public notice is required. I could have an area of my building restricted to me through an email I receive that's not posted on site. But regardless, this court doesn't have to explore the sort of outer contours of otherwise restricted, because on January 6th, the Capitol grounds were surrounded by fences, multiple layers that had do not enter signs, and police were posted at the gaps in the fence. They weren't gaps, they were fenced off, but posted behind the gaps in the Olmsted wall. And that was sufficient to satisfy any possible definition of otherwise restricted.
So if I were on January 6th cutting across the Capitol grounds, leaving the courthouse and going over to visit a friend in Southeast, and I crossed over a part where the fences had been pushed back and just kept walking, I could have been arrested and charged for up to a year imprisonment.
Yes, Your Honor. And we would have to prove that you knew you were not allowed to be there and knew you were without lawful authority at the time. And so that knowledge requirement saves the, I think is enough to allow for an expansive definition of otherwise restricted because the government bears the burden of proving that the defendant knew they were a place they weren't lawfully allowed to be.
Same hypothetical, except the person just cutting corners is lawfully carrying a firearm for personal protection. 10 years.
Yes, Your Honor. And although that may seem unfair, this is a statute designed to protect the president from assassination. And so if the Congress's intent was to err, it certainly would have been to err on the side of protection and not worry about the sort of unrealistic hypothetical of a person carrying a firearm in a place they know they're not allowed to be that is restricted. And of course, on January 6th, while there was a riot where people were attacking the Capitol and police were protecting the Capitol with pepper spray. I mean, that person.
It's not a compelling hypothetical on the facts of January 6th. I'll give you that. But we're construing the statute, and what we say is going to, if we read it broadly, it's going to apply to all of these arguably disturbing hypotheticals, right?
That's true, Your Honor. But again, the intent of Congress is clear, and no one seems to dispute that it is to protect the president and other very important government officials from assassination, assault. And that intent is furthered by requiring that a defendant have guilty knowledge, but not know the factual basis that led to the area being restricted.
I understand that. It's clearly right as a descriptive matter, but that might be a two-edged sword for you. I mean, that tends to say that the real wrongfulness that Congress has in mind here is acts targeting someone like the president rather than the garden variety trespass that arises if you just knowingly skip over the bike barrier.
Well, the legislative history suggests that that's not true, that Congress recognized that when they first enacted this statute, that the Secret Service did not have authority to restrict an area at all, that they were dependent upon the vagaries of state law trespassing charges, which sometimes would apply and sometimes would not, which they have no reason to know those details, and that this statute was meant to give the Secret Service that authority. And so if that legislative history suggests that the intent is to sort of replace state trespassing law with a federal trespassing statute, which would suggest again that all the guilty knowledge necessary is know you're in a place you're not allowed to be, because that's the traditional understanding of state trespassing.
So does the Secret Service ever do its own posting, that says keep area, restricted area? Are there signs that they carry around that specify that it's a Secret Service restricted area?
I don't know the answer to that, Your Honor. The few cases on the statute don't seem to suggest that any such signs exist. That because presidents travel so frequently and so quickly, that Secret Service works in conjunction with state and local law enforcement. And so I'm not aware of any such signs existing, but that's simply by reading the cases and not through any other.
I'm a little, the standard of review issues seem to me perhaps a little more complicated than the briefing suggests. You argue that we should affirm so long as the low bar of sufficiency evidence is satisfied. But what if we were to embrace either of the defendant's proposed interpretations? First of all, we'd have to look at those de novo, right? Or clear error. I mean, you didn't argue that their failure to move for judgment of acquittal on the grounds that they're asserting today confronts them with a clear error standard of review.
Plain error, Your Honor. We did not make that argument. I apologize if I overlooked it. But my understanding from, as recently as this court's decision in Robertson is that, the court's first task is to construe the statute properly, which is always de novo, and then to apply the next standard of review based on whether it's preserved. And here, I mean, at least in the local DC courts, sufficiency is always preserved.
Right, and we have Hilly, which preserves it. It's a little more complicated because we also have Reynoso, but how could we in this case affirm a conviction in which the fact finder did not find each element necessary if we adopt the defendant's interpretation of the statute? I mean, the district court made no finding as to the defendant's knowledge that Vice President Pence was present. And aren't we looking at that? If we accept their statutory interpretation, there would have to be enough evidence that it would satisfy harmless error, that wasn't articulated by the district court in its decision.
I don't think that's right, Your Honor. The defense has not challenged the jury instructions. They have not raised
There's
this
no
as
jury instructions.
well. The
Yes.
district court instructs itself, and so
it didn't in advance give I don't think, any clear indication on the issue that's before us now.
the defense could have pressed for the court to issue instructions or say what the instructions are and then challenge this as an instructional error case. They did not. They've challenged it as a sufficiency case. And in a sufficiency case, even where there are jury instructions, as in Catala, when the court evaluates the sufficiency of the evidence, it evaluates it the same as it evaluates it even when the jury has not made a finding, which is, could any reasonable jury have found this element? And I don't see why that would be any different in a bench trial than in a jury trial.
Well, they've made the legal argument about knowingly, right? And you agree that's properly before us.
Yeah, sure.
So if they're right on the legal point,
Then
is like a case in which there was instructional error and there's a conviction that rests on, the jury or judge didn't make all the findings that would have been necessary under the correct instructions.
I don't think that's right, Your Honor. I think the way they framed it, which is
Well,
as a
the district court goes through all of the legal issues and says quite clearly, right, the law does not require me to find that the defendant knew the vice president was on the grounds.
yeah, sure.
And under that legal construction, there's no occasion for him to make the finding one way or the other, and he doesn't.
I agree, Your Honor. But the way I conceptualize this is it's as though the defense asked for a jury instruction to a jury, the court rejected it, and then instead of bringing an instructional challenge on appeal, they brought a sufficiency of the evidence challenge. And Catala instructs us that the question there is whether there's enough evidence that a properly instructed jury could have found the element.
No, isn't it that you have to show beyond a reasonable doubt that even with the correct legal interpretation, the defendant would have been convicted without the legal error?
I don't think the government bears the burden of proving on appeal beyond a reasonable doubt. The way I read Catala is to say when they bring a sufficiency challenge where the jury hasn't been instructed, the question is whether there was sufficient evidence for a properly instructed jury to so find. And here, if I could talk about the evidence, the defendant was present at the Capitol for many hours.
Let's tie this down and then I'll let you talk about the evidence. I mean, you say they brought a sufficiency challenge, but sufficiency presupposes a legal standard, and the vast bulk of the brief is about legal standard. And you're right, they don't frame this as an instructional error, but it's a bench trial where the district court is effectively instructing itself, and that's what they're challenging.
I think this turns on the fact that they did not frame it as an instructional challenge. There's the party presentation principle. We responded to the argument they made, which is a sufficiency challenge. And here, had the district court, instructed itself that the requisite knowledge was knowledge of the vice president's presence, there was sufficient evidence from which the judge could have found that Mr. Griffin believed Pence was still president, or not still president, that's a Freudian slip, was still present at the Capitol, given all the rioters yelling things like Mike Pence, we'd love to see you come out, or you better get your stuff together, you better get your stuff together, Pence.
What about Nader, NEDER? The government has to show beyond reasonable doubt that the defendant would have been convicted even without an error that the fact finder was, an error of law under which the fact finder was laboring. And as Judge Katsas has just said, it's clear that Judge McFadden said he wasn't requiring, he didn't feel obligated to find that the defendant knew that the vice president would be or was present. So it just seems to me that in that circumstances, as I understand existing law, an issue that wasn't found is not reviewed under the lower sufficiency evidence bar. Now, is this different from a situation like Hilly, where a further requirement was erroneously imposed? And there, the court does the de novo legal analysis of what the statute requires. And if there were too many elements, then one is sufficiency of the evidence with respect to the unnecessary element is set aside, and the sufficiency analysis is protective on that ground. But here we have the inverse.
My understanding of how this works comes from Catala and from this court saying that a bench trial, review of a bench trial is the same standard of review for a jury trial. I read Catala as saying that where the jury is erroneously instructed and the defendant brings a sufficiency challenge, the question for this court is simply whether there was sufficient evidence had the jury been properly instructed. If I'm wrong, then we would request that the court remand to Judge McFadden to address the issue of the defendant's.
It seemed to me in that situation that would be the required course of events.
We don't believe it's required, but if the court disagrees, then.
So you wanted to talk about the facts. So do you think if our view of sufficiency, your opponent's view of the law prevails and our view of how sufficiency works prevails, do you have an argument that the district court's failure to make this finding was harmless under neither? Or do you just want the remand for him to make the finding one way or the other?
I think the facts are sufficient to prove Mr. Griffin's knowledge under a sufficiency standard, but they don't meet the Nader standard.
Okay.
So that we would request a remand, and certainly not this court a remand to require acquittal, which is typically how sufficient, if the evidence is sufficient, typically this court instructs acquittal. But here, where the district court didn't have the opportunity in the first place to address what we think is incorrect legal standard.
So that's reviewed de novo. And so there is something other than just a sufficiency, or at least as we've been pushing you on our premises, the premises on which our questions are based. There's a legal issue, and if there's an error of law, then that, instead of requiring acquittal, that would support remand.
If the court finds that there was a incorrect legal standard, we think that unlike many of the rioters, there is sufficient evidence from which we could prove that Mr. Griffin knew that the vice president was present or believed he was present, and thus, there's reason for a remand rather than a remand to instruct to enter acquittal.
And what
the defendant didn't mention Begay until the reply brief. Did you have anything that you haven't already said that you wanted to discuss about the context of posted and cordoned off?
I don't think so, Your Honor. Again, I don't think we're that far apart from the defense that they just seem to require a level of notice that this isn't supported by the definition of restricted, which is somehow made inaccessible in a different or a similar way to post and cordoned off. For example, they say that a chalk line on the ground is not sufficient to give notice. We think it is, but because it is on-site visible notice that something is different about the area beyond. But regardless, that's not at play here, given that the area was visibly publicly restricted in many ways on January 6th. And those restrictions were not removed lawfully, but were destroyed, moved, and trampled on by the mob. Thank you.
Just have a few points I'd like to quickly run through. The MJOA, the district court knew the council was raising these legal challenges because he thinks the government can't prove them. And he implicitly ruled on one and he explicitly ruled on the other. The court knows that the reason we're contesting, or the reason we're making these legal arguments is we think the government can't meet that burden. And then when the MJOA time comes, trial counsel says that he's got a Rule 29 filing he wants to make, but that it, quote, doesn't cover all the issues. That's late on the afternoon. And then the next morning, there's a discussion about should we have the MJOA arguments now, legal arguments, and this is where the court says that there's no need to do this now, that as far as I'm concerned, I think that he's going to address it through the bench trial and his rulings. And as far as I'm concerned, I think you could appeal any conviction on either ground that you'd be entitled to, but I don't know that it makes sense for us to go through this twice. So I would say that it was well preserved. And the government's, some of these are just connected, but let me just run through. They say the child sex, they try to make it analogous to the child sex cases. And as Elizalde says, every statute protects someone. And there's clearly this very strong and unique historical tradition and exception to the mens rea requirement. There's strict liability in a lot of child sex cases, and that is very, very unique. Then the government says that relies on the moving of the terms into the definition. We would say that our argument would have been weaker before it was moved into a definition, because then the term knowingly would have had to travel down the phrase to something past the first thing. There would have been something at the end that arguably the government could argue didn't get covered, just the where, thing. But when you put it into definition, that changes the whole meaning of what Congress is trying to do.
On that point, could you just respond to Mr. Leonard's point that C1B has its own cross-reference to C2, and no one suggests that the adverb knowingly travels all the way through to C2?
Yes, I think the Elizalde opinion explicitly deals with that argument.
Okay.
It says that the point is just that you know the fact. And, regardless of how many statutes you have to get to, just like in the heroin example, you have to go through 3 places and then find the little subsection. Regardless of how far you have to go, the question is, do you know all the facts that make your conduct criminal? That's the fundamental question. That doesn't change. And I wanted to also say a couple other things. The chalk line, I don't understand how someone's supposed to know which side of the chalk line is the forbidden side. That just doesn't make any sense at all. On the question of whether the Secret Service ever uses signage, online you can find these signs that look like this, that have Secret Service logo. That's a sign. You can look up Mar-a-Lago signs, for example, and you can see that they say, you are entering a restricted building and ground, in quotes, as defined in Title 18 U.S. Code, Section 1752, by entering this area. That sentence isn't relevant. Then it says, persons entering or remaining in this area without lawful authority are in violation of federal law and will be subject to arrest and prosecution. So they do have these signs, and there's no reason they can't be posted, but we're not requiring them to have these signs up. We're saying that if they don't have they can't prove that the person knows that it legally qualifies, they can prove the facts instead. And they're saying we didn't raise the the instructional error, but the court did reject our argument on these legal issues. And we did say, as an alternate relief in our opening brief, we say, given the district court's legal errors in interpreting those elements, a remand is required for the district court to weigh that evidence and determine whether those elements were, in its view as fact finder, established beyond a reasonable doubt. So that is I guess we didn't use the word instructional, but that's what I was trying to do there. And I think the court has picked up exactly that they are reading Hilly backwards. I mean, this isn't a situation where there was an extra element that was wrong, and we're trying to get the evidence weighed against the wrong element. No, we're saying we want the elements weighed against the right element. So for all these reasons, we would ask for the court to remand for entry of judgment of acquittal, and in the alternative, remand for the district judge to reconsider Mr. Griffin's guilt under the correct legal standards.
Thank you.
Thank you.
The case is submitted.
Case number 22-5300, Jason Leopold and BuzzFeed Inc. Appellants versus United States Department of Justice. Mr. Mouch for the appellant, Mr. Dryer for the appellate.
Morning, Mr. Mouch. You know the podium is adjustable if you care to adjust it.
Morning. Can you hear me?
Yes.
Great. May it please the court. I plan to focus on two things this morning. First, how FOIA's foreseeable harm requirement interacts with Exemption 8. And second, how the requirement applies in this case. The foreseeable harm requirement interacts with Exemption 8 the same way it does the other exemptions. As this court held in Reporters Committee, it imposes an independent and meaningful burden on agencies. That burden requires the agency to make a concrete, context-specific showing of how disclosure of the specific material at issue would, not could, harm an interest protected by the exemption. And it applies at the level of information rather than records, which means that agencies must produce redacted versions if they can do so without causing harm. Exemption 8 is distinct from the other exemptions only in the interests it protects. Those interests are surely important, but the whole point of the foreseeable harm requirement is that disclosing some exempt material will not harm those interests, in which case the public is entitled to that material. There's no reason to believe Exemption 8 is any different.
Is there any difference between the analysis of the interests in a routine bank examination as distinct from a deferred prosecution agreement?
Yes. The context of the deferred prosecution agreement is quite important here. In a deferred prosecution agreement, the bank has already agreed to cooperate fully with the monitor. Breach of that agreement results in sort of rescission of that agreement and prosecution. So in that case, the bank knows, so I take it this is related to the sort of interests in assurance of confidentiality that the monitor might have.
And cooperation.
And cooperation.
Concerns that if the redactions are going to be in someone else's hands, that a bank subject to examination and or monitor's examination would be less cooperative. And I think you put your finger on it, that the question is, really, there's a lot of incentive under a DPA to cooperate.
Exactly.
And ordinarily, a perfectly law-abiding financial institution that is being examined by federal regulators, they're under a legal obligation to cooperate, but it's potentially a different calculus. And I'm just not sure that that's something cognizable in the terms of FOIA, but I'm interested in it.
So I think it is cognizable because this court instructed in Reporters Committee that the context is relevant and important in considering the harm that would result. I would also emphasize that in the context of a deferred prosecution agreement, if the agreement is breached and the bank doesn't cooperate, sensitive information is going to come out anyway at a public trial. And that information, unlike this case, is not going to be redacted under FOIA. So in fact, this is a far better situation for a bank than, or I mean, I'm sorry, it's a far worse situation for the bank. They have less bargaining power than they would have in sort of a routine monitorship, where the consequences of not being fully candid with the monitor is not criminal liability and the prospect of potentially much more sensitive information coming out of trial. Again, here, we're not asking for the whole report. We're not asking for the sensitive stuff.
So you're starting from the baseline of the redactions that Judge Gleason approved, or something along those lines, that all you're saying is that granted, there's going to be identifying information about 300 employees that were interviewed. Granted, there's going to be information detailing processes that bad actors might want to exploit, bank processes for preventing money laundering. Granted, there might be country names and references to confidential material that foreign regulators provided, that all that would be redacted in response to the claimed interests that the government has raised. But your point is, what is the showing of harm with respect to the balance of the?
That's exactly right. That's exactly our position. Judge Gleason pointed out, I would recommend footnote 11 of his decision, where he says that some of the least sensitive parts of the report concern the monitor's processes for reaching his conclusion. The sort of general conclusions he reached, he said very few redactions will need to be made to those parts of the report. There's also the United States country report, which presumably doesn't have concerns with foreign jurisdiction information. Each jurisdiction had its own dedicated appendix, one of which was the United States. We're asking for that one. We're not asking for the 5 foreign jurisdictions. And you're right, we're not asking for information that discloses current security vulnerabilities. DOJ's conceded that many of the vulnerabilities have been rectified. Judge Gleason found the same. Sorry.
It'd be interesting to me, just following up on my initial question, whether you can elaborate at all about, if we were to hold that the foreseeable harm requirement has not been met here, how could we distinguish, or at least leave open, whether our holding would apply to routine bank examination reports?
I think you could distinguish this case, or leave it open, sort of on the grounds that you opened your first question with. Limit the decision to cases where a bank is subject to a deferred prosecution agreement, because there, the bargaining position of a bank, its leverage vis-a-vis its regulator, is different from, and maybe its bargaining position, but also the consequences from not being candid are far different from a sort of routine bank examination report.
So there, you're saying the harm is the harm to the financial regulatory system. That harm might be more, is predictable. That it would be harmful in the case where there's no deferred prosecution agreement. It is not clear that it would be harmful in the case in which there is one.
Well, I mean, I don't want to say that it would be harmful. I'm saying that it would be, the harm calculus would be different. I think the harm calculus in our case means there's less harm. You don't need to decide that case. All you need to say is that this case is, they haven't met their burden here, and that case is a different case that you're not deciding. I think that's how I would recommend approaching it.
Right, by referencing the harm, I was just trying to relate that. I mean, we understand that as a kind of policy matter, but how does it fit in FOIA? And so that's why I'm talking about the harm that would, or.
Right, so the harm that this court has articulated, this court has articulated 2 harms relevant to Exemption 8, one of which is the one I think you're talking about, which is sort of maintaining relations between the bank and the regulator, maintaining sort of candid communication between them. Yes, I think the point is, because HSBC was being prosecuted and violation of the DPA would have led to the resumption of that prosecution. The prospect of disclosing fairly innocuous information in a report is not going to deter it from not cooperating, because if it did that, sensitive stuff would come out anyway, it would get prosecuted. That's just not the case for a sort of a routine bank examination report.
What about the I mean, the foreseeable harm obligation, as you point out in Borders Committee, is one that we apply even to information that is exempt. But we also apply it differently depending on the nature of the exemption and the nature of the interest that the exemption serves. And we have our cases like Gregory, which talk about the absolute nature of the protection under Exemption 8. And we have a raft of district court cases that routinely do FOIA analysis under Exemption 8 on a pretty broad brush basis, the whole report.
So I think it's important to distinguish the exemption from the foreseeable harm requirement. I think this is the only case in which the district court has applied the foreseeable harm requirement to Exemption 8. Maybe there's others, I'm not aware of them, and this court, of course, has not done that. So yes, Gregory said something about Exemption 8 provides absolute protection to what it covers. That's not a foreseeable harm case. And so
But also absolute, but does absolute refer to scope? It's a little bit unclear.
well, so yeah, I mean, I think absolute refers to the scope of the exemption and not the harm that would result from disclosure. Gregory just wasn't asking that question because there was no foreseeable harm requirement at the time it was decided. Of course, the foreseeable harm requirement sort of could make a difference in a case only if the material is exempt. Because if the material is not exempt, the government has to disclose it whether or not disclosing it would cause harm, which emphasizes sort of the need to conduct a rigorous foreseeable harm analysis lest the provision be rendered meaningless. You're right that the analysis is different depending on the exemption. DOJ references the importance of the interest protected by Exemption 8. Again, we're not disputing that the interests are important. That's why we're not asking for large portions of the report. Of course, every exemption protects important interests. And what the agency has to do in any case under the foreseeable harm requirement is show that the interest it articulates applies to the material that it wants to withhold. I mean, it hasn't done that for the passages of the report that we are asking that they be ordered to disclose.
This may be.
Well, may I ask a question this is Judge Rogers. I'm only on audio, unfortunately.
I can hear you loud and clear.
But good. I want to be clear that I understand exactly what your argument is in terms of what you think the district court here failed to do. In other words, as I hear your argument, and maybe I'm wrong about this, you're not saying the district court couldn't reach the same result, but that he failed to do what he was required to do under FOIA, given that the district court in the Eastern District of New York had reached a different conclusion based on different findings. Is that correct? In other words, what I'm trying to understand here is, I know you made an objection to the hearsay nature of some of the government's evidence, but the district court ruled it was admissible. He could consider it, and he did. And the theory here, as we've all learned in a lot of these top secret cases, is you don't need to know the most damaging material about someone for it to have a negative impact on the government's interest in prosecution or investigation. And I sort of read the district court to think in that way too.
So let me try to answer your question and let me know if there's a part that I missed. I just want to make one correction. The district court actually, we didn't interpose a hearsay objection to everything. We did object to certain documents based on hearsay, and the district court actually agreed with us on that point. So just one small point of clarification. You asked.
So there's no argument that the district court did not properly consider the hearsay filings by the foreign governments.
Well, the district court declined to consider those materials because they were hearsay. The government is appealing that, or it's arguing that that decision was wrong, but the district court
Yeah.
declined to consider those. Yeah.
I want Judge
And
Rogers.
so your point is that absent consideration of that type of evidence, we would have to reverse.
So I think whether you consider that evidence or not, you would have to reverse. We've given 3 independent grounds for reversal here. The first is that DOJ's evidence is insufficient to meet its burden under FOIA, which would require entry of partial summary judgment for us on Exemption 8 foreseeable harm. In that case, we would ask the district court to review the monitor report in camera in conjunction with Judge Gleason's redactions. There's also other exemptions that it hasn't decided, so it would also have to consider those.
Yes,
And the
that's
partial
sort of
judgment would be
where
that
I
there-
started, and if my question wasn't that clear, it was that the district court here did not address the district court's findings in the Eastern District of New York.
Yes, that's part of the error. It also didn't address. So I mean, the Judge Gleason's findings, the judge from the Eastern District of New York, are really only relevant to our second and third arguments for reversals. The first one, all you need to do is look at DOJ's evidence, conclude that it doesn't meet its burden. We were entitled to partial summary judgment. The second ground for reversal is sort of, if you disagree with that, then both parties' motions should have been denied because there is contrary facts. One of those facts is the factual findings of Judge Gleason, and the other is the monitor's conclusion that part of his report could be released without causing harm. The third ground for reversal that we are asking, and I'm sort of going in our descending order of preference here, is the district court should not have decided the motions at all without reviewing the report in camera, including Judge Gleason's redactions. And our argument there, I fully recognize it's a deferential standard of review, and this court doesn't want to open the floodgates to mandatory in-camera review in FOIA cases. But this is an unprecedented case as far as I'm aware, because here we have a prior co-equal Article 3 judge making essentially the same analysis after an in-camera review and basically the same evidence and arguments that DOJ is making here. And on the other hand, the district court made its decision sort of without the benefit of that in-camera review. And so at least before making a decision, it should have reviewed the report in camera. We're not arguing that the district court is bound to follow Judge Gleason's decision. It should have considered it. It can redact more, it can redact less. It should at least look at what Judge Gleason did.
Suppose we think the district court erred in not performing a segregability analysis specific to the foreseeable harm question, as opposed to the underlying exemption question. Why wouldn't we just send it back for the district court to perform that analysis? It's really that court's job in the first instance.
I mean, I agree that it's that court's job in the first instance. There's no basis on which the court could make a segregability finding without reviewing the report in camera. The district court ordered DOJ to update its segregability analysis in its first opinion. And DOJ came back with specifically to address Judge Gleason's findings. DOJ came back with a very short declaration that didn't address the findings and sort of argued in a paragraph or two that they didn't matter. So on the current record, the district court just couldn't make, based on its own conclusion in its first opinion, could not make an adequate segregability finding. If you agree that, the finding wasn't made, I don't know what else it could have done based on what it had. It just didn't really have anything.
So distinguishing between your first ground and your second, your first, you said that we could hold that the evidence is insufficient to show that there is foreseeable harm, that there would be foreseeable harm from disclosure as to at least some portions of the report. And so you get partial summary judgment on some sort of undefined scope of the report and a remand for redactions as appropriate. And the second ground is that both motions should have been denied because a reasonable finder of fact could find, consistent with the Eastern District of New York analysis and the monitor's own acknowledgement that some aspects could be disclosed. Now, how are those two different? In the latter, like, we don't often have trials in FOIA cases, so would there be trial to resolve the factual conflict on whether, or I mean, it feels more comfortable to rely on burdens.
Yeah, so, I mean.
But here it seems like, according to his first opinion, that in his second opinion, Judge Contreras perhaps should have said to the government, oh, you know, if you're right, and this is all, we haven't decided the case, but assuming that your arguments have some, you know, would be credited in part, would we say, well, the government had an opportunity and came back with what it came back with in response to the district judge's first opinion, and it shouldn't get another bite at the apple? Like, how do we sort through that?
So I think in general, you're right. So just please stop me if I'm not fully answering your question, but I think there's a few parts to it. You're right, trials don't often happen in FOIA cases, and I think that in this case, it would be particularly hard to conduct one, given that the report that we are, arguing about here is fully withheld. We can't exactly disclose it in open court. I think what I would recommend is that the district court it would be sort of like a bench trial, but it just conduct factual findings, or make factual findings based on an in-camera review, and those would be the findings of the court that could then be appealed based on the relevant standard of review if either party would choose to appeal that.
Has there been a bench trial on foreseeable harm in the several years since Congress added that to FOIA?
I'm not aware of one. I'm not aware of one.
So whether we think of this as summary judgment or just thinking of this as the district court resolving the issues before him, is there any difference? I mean, the government's put in what it wants to put in, and you've done the best you can in the very difficult position of not having seen the report, and they get whatever presumption of regularity they are or are not entitled to, and you argue that on the law. And the district court will just decide this based on what he has before him.
I mean, if that includes the in-camera review, then I think there is very little difference.
Well, but the in-camera seems different from the question of sort of how summary judgment should work in a FOIA case.
So I think in general, well, so maybe this is a way to sort of parse this out. Most FOIA cases don't involve the sort of procedural setup that we're in here, because most FOIA cases are decided solely on the basis of the government's declarations. And so the question is often the sufficiency of those documents. But here
the sort of fact question just merges into the summary judgment question, because the district court assesses the government's declaration, and it's either good enough or it isn't.
Exactly, but here we have
different. So here you have that, and then you have, the statement by Churalski saying, well, you could release some form of the report, but not much. That's just part of the government's affidavit. And the Judge Gleason's analysis under strict scrutiny in a FOIA case has whatever relevance it has, but that's not going to change with a further round of factual development that we'll call a trial instead of the summary judgment record development.
So are you saying that the judge, I think that if there is contrary, I'm just sort of trying to apply Rule 56 in a FOIA case. It's
applies in a weird sort of way in FOIA cases, but it doesn't seem like Doesn't seem like the foreseeable harm requirement either was designed to or in fact has revolutionized FOIA by causing, the need for a lot of trials.
No, but I do quite a bit of FOIA litigation, and the cases that are decided in the district court based on foreseeable harm are not really that different from the ones that are decided based on exemptions. Usually it's just based on the sufficiency of the declaration. There have been bench trials in FOIA cases before the foreseeable harm requirement. Actually, I believe the Supreme Court's decision in Argus Leader followed a bench trial. So they do happen. Again, we're not asking for that here because we think it would be hard to work with given the nature of the inquiry here.
So
We're just asking for
yeah, I mean,
in a camera
summary
review.
judgment rule applies well enough if you're looking at whether the government is affirmatively, which bears the burden on the foreseeable harm point, has affirmatively shown that no fact finder could find that there is a lack of foreseeable harm as to any part of the report, and therefore some part you must be entitled. I take your position to be, therefore you must be entitled to summary judgment on those parts.
Correct. Any other questions?
Judge Rogers, any questions?
Thank you.
All right, thank you. I ask that the court reverse and remand for camera review.
Will you want rebuttal?
Yeah, I believe I had asked for 2 minutes.
We tend to mow past your time, but also give back. Okay,
Thank you.
thanks. Morning, Mr. Dreyer.
Good morning. May it please the court, Douglas Dreyer on behalf of the Department of Justice. So what I want to start on is the promises made to foreign regulators, because I think what we saw a lot of in my friend's brief and somewhat in the argument here was a focus on, well, the foreign regulators must have only cared about the portions of information that they provided. But what the record actually shows in, for instance, the Hong Kong Monetary Authority's letter, in the Bank Negara Malaysia's letter, is that they were promised that the entire report would remain confidential. So for instance, the Hong Kong Monetary Authority's letter said, "We consider it important to bring to your attention the practical difficulties that publication of the report in full or part may present to the future work of the monitor." Bank Negara Malaysia said that it was, quote, "assured that the report would only be disclosed to DOJ, the Federal Reserve Board, and UK's Financial Conduct Authority."
How do we situation in which government actors would be happy to assure confidentiality, but that can't affect the obligation of disclosure under FOIA?
So what this court said in Machado Amatis was that to withhold a responsive record, the agency must reasonably foresee that disclosure would harm an interest. Now, in order to determine whether the agency reasonably foresees that disclosure would harm an interest, one thing we're looking at is, well, what is the milieu here? And here we have foreign regulators who submitted letters to the Eastern District of New York saying they want the whole report kept under seal. And so if you're the agency looking at this record and you're seeing these foreign regulators taking the time to submit letters and requesting disclosure, requesting that the report be withheld in full, then I think it's reasonable here for the agency to say, look, okay, this entire report, this one document should be withheld in full because of these assurances of confidentiality that made, and they were written too, for instance, in the Corporate Compliance Monitor Agreement itself, it says the reports and the contents thereof are intended to remain and shall remain non-public. So we just have the prompt.
And acceptation of the monitor. And I understand if the monitor has given assurances of confidentiality, then one might expect him to exercise his discretion consistent therewith. But the caveat for except as required by law, why isn't FOIA that law?
So on that, just a point of clarification, the Corporate Compliance Monitor Agreement itself, it wasn't the monitor who determined that, it's the department. Mm-hmm. And so the language there is that except to the extent that the department determines in its sole discretion that one, disclosure would be in furtherance of the department's discharge of its responsibilities and duties and responsibilities, or two, is otherwise required by law.
Thank you for the clarification, but I'm not sure that that changes my question. unless you're making a point that you think it does.
Well, and I'm sorry, just to make sure I'm answering
The
your question.
department can determine that it wants to disclose it, but one would assume that if the monitor has said to foreign regulators, you have my assurance that that they would take him to be speaking with the authority of the Justice Department. But that doesn't resolve the except as required by law proviso.
Well, so the otherwise required by law proviso must still consider whether the agency is reasonably foreseeing harm in the Exemption 8 context. And so what we are saying is this is not just, hey, DOJ made a promise, the monitor made a promise, and we need to enforce that. We walk through in our declarations all the harms that can result as a result of the voiding of these promises. So this is not just
This is at a pretty general level. And what strikes me is that the analysis and the representations made in the declarations seem to support the applicability of Exemption 8, but they don't clearly treat the foreseeable harm requirement as a distinct and separate requirement in which the government bears the burden, even assuming that Exemption 8 applies. So the arguments that, confidence of foreign governments, cooperation of their regulators, all go to the sort of wholesale, let's withhold the report. But I take Congress to have legislated to say, even things that are covered, you look specifically, and as Judge Katsas put it, do in effect a segregability analysis under the foreseeable harm requirement.
So what I'd say on that is what we're often seeing from my friend is there's this desire of, hey, this district judge who was reversed found these certain portions could be disclosed, and therefore there needs to be more said on these specific portions. But what the agency's declarations below and in this record say is, look, we've looked at this. We've looked at the entire report. We've conducted a line-by-line analysis, which has never been disputed. The line-by-line analysis was conducted, that's attested to. And we determined that the entire report must be withheld in full. So there isn't going to be a separate analysis of the reversed findings under the First Amendment and the common law right to access.
The findings weren't reversed. I think that's a little bit of an overstatement. The Court of Appeals said, we disagree with the threshold determination that Judge Gleeson made, which was that this document is a court filing subject to the public right of access. They didn't speak at all to the findings, and in fact, they said, the proper avenue is FOIA, and we're not resolving that. So the question is, given that the same interests were raised there as are raised here, the same confidentiality grounds, and those were looked at, and we have the opinion of Judge Gleeson explaining how he responded to them. He said, I credit that, and here's what I'm doing. Here's what I'm doing about people who came forward to speak, keeping them confidential. Here's what I'm doing about the concerns of foreign regulators, leaving off all those appendices and mentioning no country names. So I'm not sure that we can say that any of that, we're not looking at it as binding, precedent, as collateral estoppel in any way. We're just looking at it almost as if it's a declaration of some expert who looked at this material, and a reasonable finder of fact could look at that and say, oh, here's someone who read the report, who knows the situation and made these determinations. What in the government submission allows us to say that none of that raises an issue?
So in AUSA Kessler's declaration, it specifically says, paragraph 7, page 108 of the Joint Appendix, although the district court and HSBC Bank USANA concluded that certain portions of the report should be released to the public, the court's analysis in that case was not conducted in the framework of FOIA and did not consider the various FOIA exemptions, including FOIA exemptions 4 and 8 or 7A, nor did the court appear to apply the reasonably segregable standard of the FOIA case law. As a result, redacting only the limited categories of information proposed by the district court would not adequately address the interests identified in the government's filings in this case, most notably the interests underlying FOIA exemption 7A and 8. And what I'd like to point to in
Word in what you just read about foreseeable harm.
it is, I mean, then it's coupled with all the rest of the declarations in the record that are going over each of the harms.
The declarations are all pretty good for you, but they're just very general. They just talk about the report as a whole.
Well, that's because we are dealing with a single document, and a single document that the conclusion is it needs to be withheld in full. And one of the main reasons for that is we cannot void these assurances of confidentiality, and that's going to apply at the report level, not at the information level.
Is that right? I mean, people cooperate, witnesses cooperate all the time, and confidentiality tailored to their disclosure concerns suffices. You don't have to close entire days of trial or entire documents in which their testimony might be mentioned. It just doesn't, so it seems to me, and maybe this is your position, it seems like you're contending that in the context of exemption 8, the foreseeable harm requirement itself has to be applied on a full report basis. That's just the unit size for the foreseeable harm requirement. There is no segregability in that context. Is that right?
I wouldn't phrase it quite like that. That's not how we're phrasing it here. I think that the point in this particular case is one of the harms is the voiding of the promises of confidentiality, and that applies at the report level. And so I agree that AA itself, the foreseeable harm requirement, speaks to information as opposed to records themselves. But here, that needs to be assessed in the context of what the harm is. And here, the harm is the voiding of these promises, which is not just an ethereal, a harm that just matters in the abstract, but we've gone through in our declarations explaining how this would harm future prosecutions, future supervisory relationships. And the regulated entity here, HSBC Bank, it had more than 400 regulators. That's in the monitor's affidavit. So this is going to require significant work across jurisdictions with different regulators working hand in hand. And in order for that to happen, they need to believe that the government's promises, which are made not just orally by the monitor, but in writing in the corporate compliance monitor agreement itself, will be honored. And if they won't be honored, the agency reasonably foresees harm would ensue. And the question for this court is whether the agency reasonably foresees harm in this instance.
So help me out,
what
because
we've been focusing on, it seems to me, is the notion that these are very general statements. Mr. Kessler is saying this could happen, that could happen. It's not as though there's any instance. And I thought the concept that the district court here was addressing was if you have a system, and by analogy, a circle, where you're getting all this highly technical, highly confidential financial information from different governments around the world, that any break in that chain could be a problem. The question, it seemed to me, that we might ask is to consider whether or not, if, and I think this is one of your hypotheticals, the table of contents is disclosed, would everyone still be adamant about absolute secrecy? And maybe so, but that's not what we have so far. And at least we have 2 district court judges viewing this case so differently, and not almost 2 ships passing in the night in terms of some of the findings. And while the department is focusing on the promises made, question would be, and much as Judge Pillard's question I thought was getting at, yes, those promises were made in light of the situation now, even after Congress's amendment, would that apply to everything? And the answer might be yes, but that's not what the government's declarations tell us so far. Isn't that correct?
Well, I do think the government's declarations go through the significant harms here that would result if promises.
No, they don't use the word would. All right. They repeatedly talk about could. And I don't want to get too technical about this, but a lot of things could happen. And I thought Judge Pillard's question was trying to focus on, yes, but sometimes in the reality, when we're talking about very specific things, views change.
So, Your Honor, what I would say, for instance, in Deputy Chief Mazur's declaration in paragraph 19, she said public release of these reports would have injurious consequences to MLR's prosecution of financial institutions. There are certainly many instances in the declarations where it says could instead of would, but there are also many instances where it says would. And on the could-would distinction in Reporters Committee itself, that says that this could-would distinction applies in the context of the deliberative process privilege. And I think there are two versions of the word could that are used.
Foreseeable harm analysis.
Right, in the foreseeable harm analysis for deliberative process privilege, which was the heart of why Congress amended FOIA in 2016, as this court walked through in the Reporters Committee. But
so I apologize. You're certainly correct. And I was focusing on the statement by Kessler. But at any rate, there are others that talk about would. Do you think then that from this court's perspective, either the segregability type analysis raised in one of Judge Katsas's questions, or just the fact for the district court to be more specific in its findings based on more specific declarations from the department, that is a useless gesture here? I realize you don't think it's required, but we're faced with sort of two very, very different approaches here.
Well, Your Honor is right that these were two different approaches. And that goes back to the heart of that. Judge Gleeson was not conducting a FOIA Exemption 8 argument. And in footnote 2 of my friend's opening brief, he acknowledges that, quote, Judge Gleeson held that the third interest, that is impacting future law enforcement efforts, was too minimal to overcome the public's access right because DOJ had chosen to enter into the deferred prosecution agreement. That sort of balancing, that's almost more akin to like an Exemption 6 type balancing. That's not the type of analysis that's conducted under Exemption 8. And Exemption 8 is written, despite the weighty interests of many of the other FOIA exemptions, including Exemption 1, Exemption 8 is the only one that includes this broad related to language that does make it unique in the statute.
I think the breadth of Exemption 8 cuts against you on foreseeable harm, though. I mean, it is super broad. It's written as a prophylactic. So then the foreseeable harm overlay says even for items that fall within the scope of the exemption, you have to figure out whether the underlying interest is served with respect to the material in question, which might implicate the harm, or it might just be there because the exemption is by design overbroad.
So Your Honor, 2 points on that. One is that's almost reminiscent of the concurrence from this court's public investors decision in 2014, which said, whoa, Congress, the Exemption 8 is written very broadly. And it cried out for maybe there should be congressional action. So then 2016
I'm not criticizing it. I'm just saying that, we have a new requirement to apply on top of it.
We do, which brings me to my second point, which is when Congress did amend the FOIA in 2016, it specifically cited this court's 1980 decision in Gregory that says that FOIA Exemption 8 has absolute protection and that the amendment was not supposed to be viewed as lessening the protections afforded under FOIA Exemption 8. Now, I think there are many cases where This court could have a lot more to say on the interplay between the foreseeable harm requirement and on Exemption A. But what I would say is on this record, with these declarations that talk about how harm is reasonably foreseen to if there is disclosure of the report in full or in part, I think on this record, the court need not go particularly far in order to affirm the district court.
Can I ask you to shift away from the affidavits for a minute, just to the district court opinions? I don't think that the court did a separate segregability analysis with respect to foreseeable harm. And I think he had to.
So as I read the district judge's.
Because he says, first time around, he says the exemption applies. It's super broad. It covers everything in the report and related to the report. And that takes care of segregability on the underlying exemption. Like, yeah, sure. If the exemption covers everything in the report, nothing in the report is segregable for purposes of Exemption 8. And then but foreseeable harm, open question, need more information. He gets more information. Second opinion comes out and he says, segregability, foreseeable harm established kind of at a general level for the report as a whole, segregability decided by my first opinion.
So as I read the district judge's first opinion, is it was deciding that Exemption 8 applies,
Right.
and it in that context discussed harm. Now, when it reached its second opinion, it noted that there had been additional discussion of foreseeable harm, and it said it had viewed that as being decided in its first opinion. So I would say I do think the district judge at least believed it conducted it. But second, we are on de novo review of the summary on a summary judgment standard. And I think.
Should we just look through the opinion to the affidavits?
I don't think we need to, but I do think we could. And certainly under Rule 50, under this court's standards for de novo review, it has that authority.
One more.
You argue that, the Congress mentioned Gregory and that we don't mean to affect the scope of Exemption 8, but Congress also carved out Exemption 3 from the foreseeable harm requirement. It didn't carve out Exemption 8. So I'm just not sure what to make of that and how to, what are you basing your effectively document level defense of non-disclosure on, given that Congress didn't carve out Exemption 8 from the foreseeable harm requirement, and that there is evidence that makes it reasonable that a fact finder would conclude that there are portions of this report that might be disclosed, that could be disclosed without causing harm.
So Exemption 3 is the only one that's statutorily carved out from the reasonable harm analysis. That's undisputed. The issue, though, is that the harms that are foreseen from Exemption 8, which this court walked through in Consumers Union, are just more apparent in much the same way that, for instance, if this was an Exemption 5 attorney-client privilege case, that the harm that comes from breaking the attorney-client privilege is something that requires a lesser showing than, say, harm from the deliberative process privilege. And what this court said in Reporters Committee was that the deliberative process privilege was the heart of why Congress was acting in 2016. And I think it's notable that, this court's two main prior cases on foreseeable harm, Machado Amatis and Reporters Committee, are both deliberative process cases because that's where more of the focus is. So it's just.
Isn't this in some ways, though, kind of akin to deliberative process? And I wanted to circle back because you had said it wouldn't protect the confidence and the cooperation with foreign regulators if all reference to their countries and the people that were spoken with and the appendices dealing with the bank in those countries were removed. That still wouldn't satisfy them. And I'm actually having trouble just understanding why that is a problem. And if you could fill me in, that would be helpful.
Sure. So, and I certainly understand that there's an intuitive appeal to say, look, a foreign regulator should only care about its own information, but that's not what the foreign regulator said. And so since the foreign regulators said that they want the entire report withheld, the agency needs to consider that when it's assessing whether it reasonably foresees harm will ensue. And so I do think that the fact that these foreign regulators were assured confidentiality, both orally and in writing, and informed the district judge in New York as to their positions on this, I think that needs to carry significant weight. And then the harm that comes from the breaking of these promises is that, look, as I mentioned earlier, HSBC Bank had more than 400 regulators. They all need to work together in order to have, in today's global world, this sort of international cooperation necessary, because not just for
That sort of cuts
HSBCs.
both ways, because I'm assuming that regulators in Malaysia and Hong Kong are eager for the cooperation of US regulators, and that
They're certainly eager in certain instances, but they also are dealing with their own laws. So for instance, in the letter from the UK Financial Conduct Authority regulator, it mentions that release of certain material here may be a violation of UK criminal law. And there's, in dealing with more than 400 regulators, there's a litany of other countries' laws that need to be considered. Now, if you're an agency who's just here to assess whether the agency is reasonably foreseeing harm from this all needs to go into your analysis in deciding whether you reasonably foresee that harm would occur here. And I just think on this record, there is a significant material in the declarations describing that the agency reasonably foresees harm. And it talks about not just that these promises of confidentiality should be protected from like a legal abstract position, but also just it goes into the specifics as to, look, if these promises are voided, then we will have less cooperation. It is less likely that regulated entities will agree to provide the information that we need. And I'll note that the corporate compliance monitor
not
agreement.
regulated entities, but foreign regulators, or both.
Both. So the promises.
Regulated entity has a lot of incentive under a DPA.
It does, but what I'll note is when the deferred prosecution agreement was signed, it came with the corporate compliance monitor agreement itself. And so in the document itself there, the promise was made that the reports would be kept confidential and full. So just from the get-go, it was. And so if that needs to be considered in assessing whether regulated entities will be more likely to provide information. And as this court said in Consumers Union, when it first really grappled with the text of Exemption 8 and Congress's purpose in the assessing the weighty interests involved, one of those key interests was safeguarding the relationships between financial institutions and the regulators.
So what about the question that I asked Mr. Match, which is, if we were to rule in his favor, can you see that as being limited to the situation of an indictment and a deferred prosecution agreement, and not where you're talking about routine bank examiner reports?
So I do think we're at the heart of Exemption 8 here, and there's a reason why my friend's opening brief and reply brief both confirm they're not disputing the scope of Exemption 8. But as for the specific question there, look, the monitor was triple-hatted here. This was not just a monitor serving for DOJ in the context of the DPA. It is also the monitor serving for the UK Financial Conduct Authority and the monitor serving as an independent consultant for the Federal Reserve Board. So this monitor report is not just in the context of a deferred prosecution agreement, it's also being used by the Federal Reserve Board as it is regulating this entity. And so I would push back at the notion that this is a report that's outside the heart because of the Federal Reserve Board's triple-hatted role here.
But there's an incentive to cooperate here that might be less if there's no deferred prosecution agreement, sort of Damocles hanging over the regulated entity's head.
regulators of financial institutions have significant power over financial institutions
I'm
in other
sure.
contexts too.
I'm sure.
But even if that were enough to somehow lessen the financial and the regulated entities' interests in that capacity, it wouldn't speak to the foreign regulators' interests. And those interests really only would apply in contexts similar to this. So I think any ruling that would be about that would risk sort of not giving enough weight to the foreign regulators' lofty interests here.
Can you give me an example about the kind of thing a foreign regulator would be worried about? You did say, oh, they were given these assurances. Like, what is going to be, how is there going to be mud on their trousers as a result?
Yeah. So one of the things in, I believe it was the monitor's affidavit, was it was talking about how, look, some of these issues that the regulated entity was addressing, issues that needed to be fixed, were things that foreign regulators may have missed in their supervisory review of the regulated entity. And so to the extent that there is a significant risk in their own countries of getting sort of egg on their face, there's also the risk that they have many other financial institutions they regulate, many of which may have similar issues that haven't been rectified, and so they have a risk of harm to their own financial institutions that could cause, especially for a smaller country that doesn't have as strong of an economy, for instance, as the United States, could cause significant damage to those countries' interests. And so just, again, this goes back to whether the agency's reasonably foreseeing harm here. Once we have all these factors to consider, and we do think that those promises, those assurances of confidentiality in writing and orally need to be upheld, and we strongly believe that this report should be and was appropriately withheld in full.
I just have one question. We're talking about a 2015 report.
Correct.
A lot of water under the bridge. Is there any lessening of the anticipated harm? The entire bank system has changed, and I assume the deferred prosecution agreement has been concluded?
So yeah, the criminal case is closed. That was closed in 2017. So what I'd say is, again, it goes back to the language in our declarations. And so the declaration specifically addressed whether the termination of that proceeding was sufficient to warrant a different result. And I'd point to AUSA Kessler's affidavit that noted in another context on page 26, it said, it is the assessment of the prosecution team in an ongoing criminal prosecution being conducted by USAO EDNY, which this was written well after the HSBC one was closed, that making the report public at this time would interfere with that prosecution. So there's still many other, deferred prosecution agreements continue here regularly. And many of the issues, even issues that have been rectified, continue to plague other financial institutions, both in this country and abroad.
One more for me. Closest thing I saw to an explicit analysis of partial redactions on foreseeable harm was the monitor's affidavit. And he said, yes, you could release a redacted report, but the problem with that is it might not be persuasive. That's the wrong legal standard for reasonably segregable.
Certainly, Your Honor, but what the monitor was talking about was not the harms that are protected by Exemption 8, but just whether the monitor's own work would be hurt. That's only one part. So what the monitor said was, I have also considered the possibility that DOJ might file a redacted version of the report. I believe that a redacted report that does not negatively impact the monitor's work can be produced. So it's just talking about the monitor's work in that one particular proceeding, but Exemption 8 is broader than that. And Exemption 8 is considering not.
So you don't you don't view that statement as addressed to the questions we've been discussing.
Well, I think the paragraph 7 through 12, right before that, go through that. The monitor who was a strong proponent of the First Amendment right to access, even the monitor said that this entire report should be withheld in full. So, this has been the government's consistent position since this issue was first raised by a non-party in the EDNY proceeding. We have consistently held that this report should be withheld in full, and we think that on this evidence with these declarations, we have met our burden here. And I requested the court affirm.
Thank you so much.
Thank you.
So we told Mr. Match we would give him a couple of minutes for rebuttal.
Thank you. I'll try to make a few points quickly. On the last point, Judge Katsas, you asked about the monitors, what the monitor was saying. If you look at the 3 or 4 paragraphs above the one that you quoted, he described the precise 3 interests the DOJ is talking about in this case, protecting foreign regulators, maintaining bank security, and confidentiality. It's clear that he viewed that as part of his work. So to say that, that's not relevant because it was part of his work, I think is to sort of miss the context of those passages.
But I think the broader context that Mr. Dreyer was pointing to is that he was considering this prosecution, not those interests as a writ large as applied to the work of the government.
I think he was. I mean, if let me turn to need to find the report in the declaration here.
The affidavit?
Yeah, it's a
42.
joint appendix, 42 to 44, thank you. So he's talking about, for example, paragraph 11. I believe that maintaining the confidentiality of the report is in the interest of an effective monitorship because it's clear to me that confidentiality encourages cooperation from the employees of HSBC Group. That's true, in the context of a monitorship and outside the context of a monitorship or a deferred prosecution agreement. On the foreign regulators, let me just read a couple of passages from their letters. Joint Appendix 57, Hong Kong. The interest of the Hong Kong Monetary Authority in this matter is the Hong Kong Country Review Report. Malaysia, Joint Appendix 59. This is in paragraph 2. It's referring to an assurance given to the Bank Negara Malaysia that any information gathered by the monitor from HSBC Malaysia would be used solely for the purposes of evaluating the effectiveness of internal controls, policies, and procedures of HSBC Malaysia. Again, Malaysia specific. And the UK regulator doesn't really say anything about its having received an assurance. I want to talk about the statute. It's incorrect to say that Congress saw Exemption 8 any differently from the other exemptions. The Senate report says something about that. The House report, of course, notes that a House member had attempted to amend the foreseeable harm requirement to not include Exemption 8. That amendment was withdrawn. So any legislative history here is ambiguous. Now, the Senate report also indicates that Exemption 5 was one of the concerns that Congress had here. Of course, if it wanted to apply the foreseeable harm requirement to Exemption 5, it would have done that. It didn't do that. It applied it to all the discretionary exemptions, so all the ones under the other than Exemption 3. On would not could, Judge Rogers, I think that's a good point. I didn't catch the one that Mr. Dreyer quoted in his argument. The one that they rely on their brief is on Joint Appendix 64 from the Mazur Declaration, where she uses would. That's a discussion of monitorships in general, not the monitor report at issue in this case. And so that doesn't meet the Reporters Committee burden of referring to this specific material at issue. I just want to close by pointing out that, again, we are not asking for the whole report. We're asking for parts of the report. The DOJ has done no analysis to determine whether those specific parts of the report, based on the interests it identifies, are exempt. Disclosing any part of this report, which remember is very controversial when written, remains controversial today, even if small and innocuous, could go a long way toward promoting the accountability promised by FOIA and strengthened by the foreseeable harm requirement. If there are no more questions, I'd ask the court reverse and remand for in-camera review.
Thank you both very much. The case is submitted.
Case number 22-7136, 3534 Cap Venture LLC and McCullough Construction LLC appellants versus Westchester Fire Insurance Company and Endurance American Insurance Company. Mr. Brown for the appellants, Mr. Silverberg for the appellees.
Morning, Your Honors, and I represent 3534 East Cap Venture. They were insured. They bought a policy of insurance from the defendants in this case. Actually, two policies are identical, each covering 50% of the coverage. They had express coverage for water damage. Water damage, when you look at the definition of flood and water damage together, water damage is defined as the accumulation of water from any source, not a covered source, any source on a roof or other surface of the building. In this case, there was a lack of a vapor barrier that was installed. Water accumulated in the space between the roof and the walls and the ceilings in the building. That water soaked insulation. It soaked all the porous materials, drywall, wood, and that was the damage that was caused. There was no damage caused by dampness, that is humidity. Humidity dampness is something that could cause cupping of floors, that could cause, for example, like the Sally case, the case Scottsdale versus Sally group, it caused cigars to delaminate and become useless. That's not the kind of damage we had. Everybody agrees the damage here was from actual wetting.
So, Mr. Brown, what is the covered peril that caused the loss that would have otherwise stemmed solely from the lack of a vapor barrier?
Well, it was the accumulation of water. That is, water damage is the actual peril that caused the loss. The actual wetting of porous materials in the building. Your Honor,
Condensate?
Well, Your Honor, this policy doesn't have a condensation exclusion. Some policies do, but yes, this is water that if you had a condensate, you have actual water that forms and accumulates on the bottom of the roof deck is what it was. And there are multiple references in the record, and I'll let you know where they are, that it was liquid water, actual water that formed within the bottom of the roof deck and the walls that caused the actual damage. No damage from humidity. And Your Honor, under this policy,
Condensation only occurs where there's humidity.
well, Your Honor, what we're doing is define or reading what the policy says. And if we look at the two exclusions that have been applied here, Judge Mehta looked at two exclusions. One's the cost of making good. It's a fascinating exclusion. And the other one is the dampness or dryness of atmosphere. Kind of a mouthful. The first one, Your Honor, is the cost of making good, that is the cost of putting a vapor barrier in, are not covered. However, and that's directly out of the policy. However, if direct physical loss by an insured peril ensues, then this policy will provide coverage for such ensuing loss only. That ensuing loss is water. There's no question that the water resulted from the lack of a vapor barrier. And you know, Your Honors, we know that because when they put the vapor barrier in, no more water damage occurred.
If direct physical loss from a covered peril ensues, how can we say it's direct where the reason that it built up was the lack of a vapor barrier?
Well, Your Honor, if all we had was humidity or a lack of a vapor barrier and high humidity, we had no damage at all, none. The direct damage was the direct wetting of the porous materials. Now, Your Honor, a little bit on the procedural posture of this
The only
case.
way it gets up under the roof is because there's humidity in the air, there's cold, it condenses.
That's correct, Your Honor. So we have a condensation, right? If we have a vapor barrier, the condensation occurs on the outside of the vapor barrier. If we don't, it occurs on the inside of where the vapor barrier would be, which is inside the building. The actual damage is done by the water damage. And water damage, as Your Honor, I've told you, is defined as accumulation of water from any source. Excluded, non-excluded, doesn't matter. Insurance company could have said accumulation of water from a covered source, but they don't. It's any source. And Your Honor, the first cost of making good we just talked about. The second one was the policy does not insure loss caused by any of the following unless direct physical loss by an insured peril ensues. And once again, the physical loss is the water damage, not the humidity. Water damage. And Your Honor, the case of Sousa versus Corvick is the one that talks about what does that mean? What does ensuing mean? District of Columbia follows a reasonable man standard or man in the street standard. Right? Would a reasonable man or a man in the street believe that I'm covered for water damage? I have water damage that resulted from a design defect, if you want to call it that, of a lack of a vapor barrier. That water damage resulted from. And Your Honor, this court said expressly that the most common meaning of ensue is to result from. And Your Honor, I went back and I pulled a couple of definitions out of ensuing from the Cambridge Dictionary. It's exactly that. It says to happen after something else, specifically as a result of. Miriam's was to take place afterward or as a result. And there's no question that the water damage resulted from something. And in this case, lack of a vapor barrier. The direct damage was done only by the actual wetting of these materials by a covered peril. How do we know it's a covered peril? Because the policy tells us it is. There's a $50,000 deductible for water damage. The deponents who were deposed for the insurance companies told us it was water damage. Mr. Morgan, Jeffrey Morgan, who was the deponent for Westchester, was asked a question and said the damage wasn't caused by extreme temperature, which was one of the other excluded areas. It was caused by the water. And we know it was water damage. Richard Keelty, who was the SOMPO representative, said moisture damage to me means just the presence of heavy moisture in the air that causes damage per se. We didn't have that. He says water damage is from the actual liquid touching a surface. So, Your Honor, what we had was actual water damage. And just to let your honors know, this case came up for summary judgment before experts were identified. I guess we didn't have any expert testimony. And it was at a stage based on simply the language of the policy. There were no experts who said, look, humidity is what caused this problem. There were no experts who said the humidity in the building was X, the humidity outside was Y. Those were just not facts in this case on this record. Your Honor,
So the relief that you were seeking is a remand for further consideration and development of expert testimony?
Well, Your Honor, I actually think that under this record, it's absolutely clear that we had water damage.
I guess that's what I'm asking. Did the parties, and I looked into this, but I have a lot of different things in my brain today.
I get it, Your Honor.
Did the parties brief this up on summary judgment as a kind of almost like a bifurcation where there may be further proceedings and you've reserved the right to have experts, or did you just decide to forego?
No, it was done expressly that way, Your Honor. And in the scheduling order, we scheduled summary judgment argument before experts. And that's often done in these insurance cases because a lot of times, the big money's in the experts. We want to try to get this resolved if it can be resolved on the language of the policy. I think the language of this policy does cover water damage. We know it covers water damage. And the fact that that water damage resulted from a design defect or humidity doesn't matter. In fact, it's expressly covered as an ensuing loss. That's exactly what it means. A reasonable man would say, look, if it follows from, if it ensues from, it's clear. The Corvick case, Your Honor, the excluded element was settling of the building, settling of the house. Question was whether the damage to the broken windows and a heating element in the house were covered. What was covered was an ensuing loss if it was breakage of glass. And the court said, yeah, that's covered. The broken glass didn't result from a rock or anything else. It resulted from the settling of the house, or at least the court said that was the evidence that the plaintiff went. Now, Corvick came up on a directed verdict. Sort of standards are the same, but in our case, a little bit different. Simply because in our case, Your Honor, we have a definition of water damage, which is very, very broad, written by the insurance companies, not us. Water, accumulation of water from any source, not any covered source, not any covered peril, any source is covered under this policy. Also interesting in this policy.
District court district court relied on this Bethany case,
Yes, Your Honor.
right? You have the causal dynamic in all of these cases seems to be you have the excluded peril. In this case is the humidity. It causes the covered peril, which is the water damage. And there's an ensuing loss clause. What happens then?
And
So Sousa seems helpful to you on that point, but Bethany, maybe not.
well,
The court there, on the one hand, it says, well, Maryland law, which is extra persuasive DC law, just has this results from standard, same as Sousa. But then when they go on to apply it, they say the ensuing loss clause does not apply if the excluded peril and the ensuing covered peril are inextricably intertwined.
And Your Honor,
What do you make of that?
well, I'll tell you what I make of it. Number one, it's a Maryland case. I was Judge Hollander. I know the case very well. But Your Honor, we're in the District of Columbia. We're under Sousa. And Sousa said, look, under this standard, they said, look, we applied ensuing and said it's an ambiguous term as applied. Here, Your Honor, I think it's pretty clear. If the water damage didn't result from the design defect, it wouldn't be an ensuing loss. And if it didn't result from dampness of atmosphere, it wouldn't be an ensuing loss. It is in this case. Let's say the dampness of atmosphere didn't have anything to do with it. The exclusion doesn't apply. Well, I don't have to go with the ensuing loss, but I have direct coverage for water damage. Your Honor, I think in this case, that was our first point. The Blaine case is another case that we've looked at. Now, obviously, it doesn't come from Maryland, doesn't come from DC, but it's identical. It's on all fours. And what the court there focused on was this sort of curious language, dryness or dampness of atmosphere. And they said, well, what does that mean? Why don't they just put dryness or dampness there? But they say of atmosphere. And the court then went on to make a distinction between atmosphere outside and atmosphere inside. I would submit, Your Honor, that the Sousa case is different than Maryland because we have a reasonable man standard or man on the street standard. And when I went through and I looked at the cases, there's a lot of cases on this ensuing loss clause from all over. But the cases were in the states that apply a reasonable man standard or apply a man on the street standard, all apply ensuing loss as resulting, just plain old resulting. And they don't go into this complex, it has to be ensuing from some other loss that's not excluded. The Roger Cleveland golf case, which is a California case, said, and they have a reasonable man on the street standard, said that moisture that comes up from a concrete slab and forms a mold on a rug is covered because it ensued from the dampness and atmosphere. Old Town Canoe, which is a Maine case, some canoes are put into a store. I see my time's run up, Your Honor. Do you have any further questions?
Judge Rogers, any questions?
No, thank you.
Thank you, Your Honor.
Thank you. And are you requesting time for rebuttal?
Yes, Your Honor. I requested 2 minutes of rebuttal.
We'll give you those 2 minutes. Morning, Mr. Silverberg.
Good morning, Your Honors. I represent the appellees, insurers, and if it may please the court. This case boils down to atmosphere and dampness of atmosphere in an exclusion. The policy is an all-risk exclusion. It ensures all risks unless otherwise excluded. Judge Mehta got it right. Dampness of atmosphere is an exclusion in the policy. To do what appellants argue here basically eviscerates the exclusion. Your Honor's questions, I think, got to that point. And frankly, before there was litigation, before advocates got involved, the appellants, the parties, referred to it as condensation, dampness of atmosphere. This was not a hole in the roof where rain came in. If this was a hole in the roof where rain came in, if this was a plumbing pipe that broke where water caused damage, I wouldn't be here right now.
What does the ensuing loss clause do?
The ensuing,
Yeah, that's saying there's an exclusion, sure, but there's an exclusion to the exclusion.
Sure, and well, there's an exception to an exception to the exclusion. You're exactly right. And there's a lot of case law on the exception to the exclusion. And the Bethany Beach case, the court deals with it, at least under Maryland law. The Jowett case, I would certainly refer your honors to Aetna v. Yates. The exception is not designed to swallow up the exclusion. And your honor's question earlier got to that point, and Judge Mehta got to that point, inextricably intertwined.
But it's not. I mean,
Well,
you can imagine all sorts of damage from humidity
yes.
that don't involve water,
Okay, and
including condensation.
well, condensation does indeed, I would submit, involves water, and it is inextricably intertwined here. But I can give an example to put, some flesh on the bones of
I mean,
what.
the ensuing loss clause, to me anyway, seems to apply by its terms. And your best argument is you can't apply it by its terms because it would eviscerate the humidity and temperature clauses.
Well, that is exactly right. And I would also note that the exclusion refers to caused by dampness of atmosphere, not dampness of atmosphere. And counsel talked about the policy covers water damage. Well, it does cover certain kinds of water damage. We've never run away from that. If you recall, I started this argument by saying it's the risk policy unless otherwise excluded.
I thought it covered all water damage unless otherwise excluded. And the exclusion is, you're saying, well, water in the form of humidity excluded, but as Judge Katsas's question pointed out, there is damage that is caused by humidity in its atmospheric form.
Right.
Like the mold that forms on the outside shingles of my home. But this is not that. This is liquid water, as their brief pointed out. And so then the question is, even assuming that there's an exclusion for atmospheric humidity, and they make an argument that there's at least enough ambiguity that that's limited to outdoor atmosphere. Here they have indoor liquid water. So why isn't that either under ensuing loss or just under the terms of the agreement, or both?
I would submit that when you consider dampness of atmosphere caused by dampness of atmosphere, that is inextricably intertwined.
Wait, dampness of atmosphere caused by dampness of atmosphere?
No. Dampness of atmosphere in and of itself clearly connotes moisture, water.
It's moisture in a particular form, whereas water, at least read contra preferendum in the insured's favor, is a liquid.
Right. Well, so we have an exclusion that says dampness of atmosphere, or anything caused by dampness of atmosphere. And I think that is the key here. So they are close.
So if dampness of atmosphere creates rust, and the rust damaged some drain that was supposed to, or some, lock that was supposed to keep my sheep in. And I mean, I think that I understand the peril to be the thing that directly itself causes the harm, not the thing that's up the causal chain.
Right. Well, there's no, and the example you started to give, and I've been saying, I'd like to sort of give an example where the ensuing loss has life but doesn't eviscerate the exclusion. So you sort of had, Your Honor sort of proposed a chain of events. So let me give maybe even a simpler chain of events. You have an exclusion for corrosion. Okay, a pipe corrodes, floods the premises. There you have a not otherwise exclude, arguably a not otherwise exclude ensuing type of loss, or some sort of chain of events that results in a collapse, dry rot, as that knocks out a beam, and then an entire building collapse. And if collapse is not otherwise excluded, I think that's an example. Here you have an exclusion.
How is that different?
Well, I think it's very different because you are taking a really a segregated type of peril, collapse, to perfectly otherwise undamaged property. Here, what happened was the moisture, the humidity, the dampness of atmosphere did what humidity, dampness of atmosphere does, and it damaged through a version of water damage. I mean, clearly we can't sort of separate humidity and this notion of vapor. I mean, the appellants were calling it condensation. They put in the vapor barrier, it went away. It was clearly the purpose of this exclusion. It was clearly accomplished. And if I could just, Yates, Aetna v. Yates, I think really deals with this issue, where the court said plaintiffs put more weight on the last quoted clause, the ensuing loss clause, than it will bear. The result of their construction would be that the clause intended to narrow the exclusions for rust, rot, mold, or other fungi, and dampness of atmosphere would very nearly destroy them. A court may not properly give the clause such an unnatural effect unless the words compel. That was the Fifth Circuit, and that dealt with dampness of atmospheres and others. But that's my point. So I do think, the ensuing loss is there for a reason, to address covered perils, and this is not that scenario.
In the hypothetical, in your corrosion hypothetical, if I followed it correctly, the excluded peril, just the corrosion, it might cause some loss, it might cause a loss by causing a covered peril, right? Which is the drain bursts or something.
Exactly.
Which is covered.
Right, some sort of
Or
segregable
might
type.
cause some other kind of loss, which would be excluded.
Yes.
I mean, the words I just said describe this contract just as well. It's just that the causation is less dramatic. It's not like a fire and earthquake, but
well, I think,
why does that matter?
Well, Your Honor's words are less dramatic. My words would be inextricably intertwined, as were Judge Mehta's words, because when you look at...
But why is that true if you have harms from dampness which don't involve water?
I mean, it honestly would depend on the scenario. But here, dampness and water, that is not a leap at all. And when you look at the cases that dealt with it, and certainly, I recognize in the Blaine decision, Judge Mehta and appellees went to what we thought was the better reasoned dissent, but even Yates, same thing. And I would just also add, if you look at, because when we got the court's order to show cause, which put me into a tailspin Friday afternoon to look at the Sousa case, one of the first things I did was shepherdize it. And it's not widely cited, which is not a knock, just an observation, but it is cited by the United States District Court for the District of Columbia in the case of Sum Inc. versus Hanover Insurance Company. And it's a very similar case where, again, the court goes through the ensuing loss and looks at
that site. You just give it.
Oh, I'll give it to you. Yes.
I know we dropped this on you.
No,
I apologize.
And I have to find the site. It's 2023. It was decided since East Cap. In fact, it cites East Cap. Westlaw 1861066.
Okay.
And that is one where it involved a similar type exclusion with faulty workmanship with ensuing loss. And again, the insured's plaintiffs argued for, trying to separate out the so-called ensuing loss, the cracked concrete and other members that were a direct result of the faulty workmanship. The court goes through Bethany, goes through Bethany Beach, and it also, the plaintiffs cited to the Sousa case, and the court said that argument does not withstand scrutiny primarily because the defined defect exclusions and exceptions are not ambiguous. Again,
Do you see a meaningful distinction between the Maryland treatment that the Maryland federal courts have used and the treatment in Sousa? Sousa doesn't explicitly talk about
No,
inextricably intertwined.
no, it doesn't. It's, I read it and read it and read it, and I did not see a meaningful difference. And I, frankly submit that this one, for the reasons largely stated by Judge Maida, largely noted by the Yates Court, by the Aetna v. Yates Court, the Fifth Circuit, that dampness of atmosphere, it is not, it's a bridge too far to then start calling soaked or, moisture damaged, water damage. Well, we can use the word water damage of insulation because of a lack of a vapor barrier. I think it's a bridge too far to say that, aha, now you have the exception, because essentially the exclusion would bear no weight and would really be swallowed up by the exception.
Sorry, this is Judge Rogers. Let me just ask you, following up on Judge Pillard's question, in both cases, you could say, well, the court was looking to provisions of a policy that it was being argued were ambiguous. But would you not see a factual distinction between the Sousa case and this case, wouldn't you? Because there the policy read in a very different way. And the question was, as I recall, and you can correct me if I'm wrong, was the damage caused by an explosion or glass? And so the policy applied in one instance and didn't in another. Well, we don't have that situation here. The question is water. And everybody agrees there was water damage, as I understand it. And the question is, well, what do you call it? And the policy here says any water damage except as, and then I suppose your strongest argument is, well, the homeowner here, the policyholder, referred to it as an exclusion. So that's certainly not the technical term that insurance policies use. But perhaps that was raised in the context of saying, well, there was no obligation under the policy to actually to put in the vapor recovery system. So all I was getting at is that when you read Sousa, the district court there seems to be saying, unlike the Maryland court, that you can read this ensuing clause broadly where you have this ambiguity. Or maybe you can even strike the adverb and just say where you have an ambiguity, the ensuing loss clause takes on a different meaning. That's all I'm trying to understand here. And I thought maybe that's what Judge Pillard's question was getting at when she said, well, is there any meaningful distinction? And even if we were to agree that there's no meaningful distinction in the sense of the phrase ensuing loss, there certainly is a difference in terms of the factual basis of the two cases, is there not?
I believe, if I'm understanding Your Honor's question correctly, I believe there's a very significant difference in where in the Sousa case, the court had determined that subsidence or the sinking in the earth, they decided that that was long-term, and that's not what occurred here. So, at that point, sort of got out from under the threshold issue on the exclusion. Here, there is no dispute that it was about the absence of a vapor barrier, and that once the vapor barrier was installed, problem solved. And if a vapor barrier had existed, there would not have been this dampness of atmosphere issue, which caused the damage, which is the subject of this lawsuit.
But even your argument, it was water, and you're saying it was atmospheric water, not the water that the plaintiff is arguing, even though the clause your client has is any water damage, very broadly stated. And certainly in the Sousa case, the court was focusing on what was the cause in terms of, was it an explosion or was it this glass problem? So it just seems to me that the factual basis for analyzing the meaning of the clause was different. And to the extent Maryland law was being read as saying, well, you can't do that, there is a more generous reading under Sousa.
And I think Your Honor, in Your Honor's question, I think made an excellent point, because what we are talking about here is atmospheric water. We're not talking about a hole in a roof where rain came in, or where a pipe burst and caused damage.
Why isn't it just like a pipe bursting and causing damage? It's a pipe is bursting for an antecedent reason that might be corrosion, and maybe the corrosion is excluded, but the ensuing loss provision on, I'm inferring on the hypothetical, brings the water damage from the burst pipe back under coverage. Here, to the extent that some amount of, accessible humidity somewhere is what contributes to the ability of the water buildup, it's the lack of a vapor barrier and, in fact, water in liquid form that causes the damage. Why is that not just like your pipe?
Because I think, Your Honor, with respect, that essentially, which is not the way policies are to be read in Washington, D.C. or Maryland or virtually any other jurisdiction, it basically reads out the exclusion. When is the exclusion almost ever going to apply? I think one has to also consider the context, and this is about ensuring structure, a building, where most of the exposure to damage is going to be interior. And I think for all those reasons, to read it so narrowly and to, what about this, what about that? It all involves water, clearly dampness of atmosphere. I mean, let's think about what was missing here, a vapor barrier. I mean, it was all about protecting from moisture water. This was not about, rain or a pipe burst. If I came in here with that argument, I would be sitting at the other table, I suspect. I don't know if Your Honors have any other questions.
Rogers?
Thank you.
Thank you, Mr. Silverberg. And we'll hear briefly from Mr. Brown on rebuttal.
Thank you, Your Honor. Very quickly, if the insurance company had wanted to use the words inextricably intertwined, they could have put it in there. They could have written it right into the policy. But instead they didn't. And what they told this insured was, if you have water from any source, water, we're going to cover it.
If we think there's an inextricably intertwined exception to the ensuing loss provision, you lose?
I don't think so, Your Honor, because this is not a case where the ensuing clause would eviscerate the exclusion. Let me explain to you why. In this case, humidity damage or dampness of atmosphere can cause loss, can cause damage. Now, I will caution the court that there are all sorts of policies out there. There are policies that exclude humidity. This one does not. There are policies that exclude condensation. This one does not. So reading other cases, you need to look to make sure that those aren't excluded causes. But in this case, cigars that go bad, from high humidity and have to be destroyed, no water damage, humidity damage, dampness of atmosphere. Floors that cup because of humidity, but not because of water, are damaged from dampness of atmosphere. Warped woods on cabinets, would be something that would be covered. Surface rust would be covered. And most importantly, electronics that fail to work because of dampness of atmosphere and corrosion within the electronic motherboards is also something that would be covered by the dampness of humidity, but not picked up by the ensuing loss clause. The reasonable man on a street would say, look,
Well, and
I'm
you
com-
thought it wouldn't be, if the electronics are indoors, you think it wouldn't even be covered by the exclusion because you think dampness atmosphere is exterior.
well, Your Honor, if this is an all-risk policy, so it covers all risk of loss unless it's excluded. Burdens on the insurance company to show clear exclusion, clear application. In this case, they haven't done that. So if I have a TV that fails to work, I say I'm covered, I have a loss to my TV, they say dampness of atmosphere, maybe they got something. Thank you, Your Honor.
Thank you both. Case is submitted.
Thank you.